Hello, hello. This is Kenya Rahmaan, the author and founder of the Child Support Hustle. Hope you're doing okay today. I'm doing pretty good. Thank you. If you're asking out in the world, I'm doing just fine. Thanks. And as the caption says, there's what I think is a big deal in child support news because this hasn't happened before that I've seen or that I've read about as far as um, uh, a contempt of court case being successfully appealed by a parent. So this is a big deal. This is a lot of information. Hey, D Parks, and that's why I came on kind of early. I'm trying to still figure out where my right time is. Hi, Stephanie. When I can, reach the most people. But I figured people always go back and watch and everything. So it's like whenever I try to get in where I fit in. But this is a lot of information, so I'm gonna jump right in. I'm done saying, I just jumped on here real quick because really, is anything really quick nowadays? And this definitely isn't. But this is great. So we're gonna start. And on January 6th of this year, Colorado Court of Appeals announced that the case against this father's name is Joshua Broyhill, Broyhill, have found him in indirect contempt for failure to comply with the child support order and imposing a jail sentence as a remedial sanction was unconstitutional and would be remanded back to the trial court. Whoa. I mean, that's just wow. And how they found it out. I mean, they broke it down. So, it's just somebody and how I'm looking at is like, wow, somebody finally recognized that what has been happening to parents all over the nation for decades. Finally, some judges in Colorado said, you know what, this is unconstitutional, and this is after Turner. So that's why I'm like, wow. Okay. So Mr. Broyhill argued that the trial court violated his right to due process by failing to appoint counsel to assist him in his defense on the contempt citation. Here are some facts in the case according to youngwilliams.com. And then instead of me going back and forth and saying according to Young Williams, this whole document is from youngwilliams.com. So instead of me saying direct quote or whatever like that, that's where I got this form, the case file or the case document. And of course, that's going to be in the description. So you can go back and look at it, reference it, all that good stuff. So throughout the contempt proceedings, Broyhill repeatedly told the court that he was indigent. He contended based on his indigency and the fact that child support services were pursuing imprisonment as a remedial sanction that he was entitled to a court-appointed counsel at state expense. The trial court denied it. I'm going to say court. Of course, we know it was the judge, but I'm going to use trial court, sometimes judge, but I'm not going to get in semantics. Some people will be like, well, a court isn't a judge and vice versa. Well, just before you type or say that's not the, got it. The trial court denied his plea for an attorney. The judge said that the request on the grounds of that the right to court-appointed counsel doesn't extend to contempt proceedings where only remedial sanctions and not punitive sanctions are requested. And that's a big deal. I mean, that's a big part of the argument on whether somebody going in front of a judge for contempt should or should not have a lawyer appointed to them if they can't afford one. So according to a report by Stephen Cook and Jennifer L. Noyes, Noyes, remedial contempt, is intended to compel compliance with the court order, and punitive is intended to uphold the court's authority. So that's the difference. Before the case was appealed, Mr. Broyhill was administratively ordered to pay $183 per month in child support, and that was in 2004. In 2015, the Pueblo County Child Support Services petitioned the trial court to register the foreign order, which originated in Iowa. So this wasn't even a case out of Colorado. This was out of Iowa from 2004. So I'm thinking that because the mother is never mentioned, never quoted, never brought up in this in the original trial in the transcripts. So this is all the child support agency. So I'm thinking the child support agency probably did an audit and said this is an old case with some arrears owed on it. Let's pursue this father for contempt of court, and that's how this case came about, because they never reference her, so she probably wasn't there. It's just the child support agency, their lawyer, Mr. Broyhill, and then the judge. So in September 2018, the CSA, the child support agency, on behalf of the mother, filed a motion to issue an indirect contempt citation against Broyhill. They alleged that he had unpaid child support balance in the amount of $11,929. The punishment sought by the agency was a remedial sanction of a jail sentence for an indefinite period of time not to exceed 6 months. The judge issued a contempt citation advising Broyhill that the agency wanted a remedial contempt charge. The judge told him that he had a right to be represented by an attorney, but he had to pay for it. The court documents show that there is an emphasis on him having to pay for his own attorney. And we have to remember that he's declared himself indigent from the very beginning, saying he doesn't have any money, he can't afford not only a lawyer, but he can't pay the $11,000 that they want in child support, nor can he pay the monthly child support because he has no money. After being served with the contempt citation, Broyhill appeared before the trial court to be advised of his rights. He again told the judge, he's saying this the whole time, that he, quote, that he had, quote, the right to be represented by a lawyer of his own choosing, which should he wish to hire one. I'm sorry, he was told by the judge that he could have a lawyer, but he had to hire one. And again, he told the lawyer that told the judge he couldn't afford one. So I'm getting all this information again from Young and Williams. The case document goes on to highlight that Broyhill continued to tell the judge that he was indigent, telling the court, among other things, that he couldn't afford an attorney, that he had very little money, and that he needed to find a pro bono attorney. This occurred throughout the 5 conferences that were held over a 4-month period. So they had time to get him an attorney. They had time to offer him safeguards to see if he was truly indigent. They had time to do a bunch of things, and they did nothing. So I'm going to highlight certain points. You go back and read the whole case file because it's kind of long and very detailed, which I'm glad it is, because hopefully other jurisdictions can take this, since they seem to ignore Turner, and at least, have another case file that they can go by, and parents can have another case document that they can look at and show to the judges or the agency and say, look, it says it right here. You cannot hold me in contempt without doing A, B, and C. So Broyhill said in part that, quote, I honestly believe that I'm entitled to a court-appointed attorney, end quote. He cited a Colorado Court of Appeals decision made in 1982 of Padilla v. Padilla, referencing the entitlement to an attorney for an alleged contemptor. Broyhill said that he would like an attorney and the right to prove his indigency. The judge asked the attorney for the child support agency if the contempt charge was remedial, in which they applied that it was. The judge replied, quote, yeah, okay, all right, sir, that's not my understanding of the law. This is remedial contempt, not punitive contempt, end quote. So the judge knew what it was and still denied his right to an attorney, and that they didn't give him an indigency hearing. That's all violation of due process. I want to stop right here and say that even if the charge was remedial, and he was not entitled to an attorney per the SCOTUS, the Supreme Court of the United States decision of Turner versus Rogers of 2011, he still had a right to prove indigency or ability to pay before they pursued him any further. Specifically, according to the Federal Office of Child Support Enforcement, generally a show cause or other contempt action should only be initiated in these cases where there is evidence of the non-custodial parent's ability to comply with the underlying child support order and evidence that there is actual and present ability to pay the purge amount ordered. And we know the purge amount is what somebody can pay to buy their freedom. So if they have that money, they can buy their freedom, purchase their freedom, and they basically hold the keys to the jail cell. That's how contempt is supposed to go in these cases. But the child support agencies, the government has violated the Constitution and pretty much went crazy with it. And so they're just locking everybody up. So that's why this case is so critical. Let me see. I'm sorry, guys. I lost my train of thought. So based on Turner, and I'm going to go over this, if the caseworkers in the child support agency had reviewed this case and studied to see if Mr. Broyhill was in fact indigent, this case would have never and should have never went to a trial judge. They should have stopped it from right there. And that was based on the Supreme Court Turner versus Rogers decision back in 2011. So the judge proceeded with the case, the agency with an attorney, Mr. Broyhill without one. He testified that he had disabilities preventing him from obtaining long-term and gainful employment. Throughout the hearing, he continuously asked for an attorney, asserted that he, quote, honestly believed that the court should appoint me a lawyer based on the case law that I've read, end quote. So he's even bringing up case law, and the judge is saying, oh, no, that's not what's going on here. Hold on one second, guys. Thank you. So part of the judge denied his pleas for a lawyer and found him in direct contempt because he failed to prove his disability status. Part of the remedial sanction included 30 days in jail with a stayed sentence. The postponed sentence was based on him remaining current on the child support payments, which he wasn't. The judge did not determine ability to pay past or present payments. Mr. Broyhill appealed with the help of a pro bono attorney. The agency did not answer. So when they filed it, they never said anything. But why would they answer? They're used to getting away with constitutional violations like this one without any repercussions because there's zero accountability. They do this stuff all the time. But Mr. Broyhill fought back, and I'm so happy that he did, and I'm so happy that he won. In his appeal, Mr. Broyhill contends that the judge denied him, quote, due process of law under the 14th Amendment to the United States Constitution by failing to determine whether he was indigent and thus entitled to a court-appointed state-paid counsel, end quote. And the Colorado Court of Appeals agreed. Okay, so here are some facts that help determine the ruling according to the case. The judges are as follows, and the opinion was given by Judge Craig R. Welling and Judges John Daniel Daly and Judge Matthew D. Grove concurred with the opinion. As to Mr. Broyhill's claim that he was denied the right to court-appointed and state-paid attorney based on indigency, Judge Welling referenced the SCOTUS case of Gibson and Wainwright, and that was way back in 1963, in which the SCOTUS unanimously held that the Sixth Amendment to the Constitution through the 14th Amendment requires appointment of counsel at state cost for indigent defendants in state felony trials. Next, the judge wrote that, quote, the danger of the state erroneously taking a person's physical liberty led the court to declare it an obvious truth that the indigent person can't be assured a fair trial against the judicial machinery unless counsel is provided at no cost. I'm not going to read that all again, but that's some serious stuff right there. In 1972, the right to an attorney extended to misdemeanor cases where imprisonment was a possible punishment. That's where a lot of people go back and forth with the right to an attorney in contempt cases, go back and forth, a right to one, a right without one. If you are facing imprisonment in a contempt in a contempt case, that's when you are supposed to get an attorney because you're facing prison. But in child support cases, they ignore it all the time. You guys know that. The judge writes again that the Supreme Court articulated the principle that Sixth Amendment secures to indigent people the right to appointed counsel in every contempt proceeding where imprisonment is a real threat. This is child support related, but this is a problem that affects citizens who do not have child support cases. Inability to pay child support has been a gateway to the government being able to incarcerate poor people just for being too poor to pay a debt or a fine or a ticket or court costs, things like that. And they've even moved over to medical bills and bills like that. Companies can sue a person that owes a debt and they can be held in contempt. But the gateway started with child support because people accepted it. They cheered for it, and you hear it all the time. Oh, he need to go to jail if he don't pay his child support. Put his ass in jail, or they need to go to jail or whatever, and it's okay. But nobody ever sits back. Well, they do now, but people didn't look back and say, well, if he didn't have a job or she didn't have any money, why would you send them to jail? One, they're not getting any money, and two, neither are you. But it was unconstitutional to send somebody to jail anyway. But when the same thing happens, people are starting to pay attention now because if the same thing happens to the little old lady down the street or the mom with the kids that lost her job, then people start having sympathy. Nobody should be arrested because they cannot afford to pay a bill or a debt, especially a government owed bill. And we know this is the case of Title 4D cases because the mother is represented by the agency instead of a private attorney. She already has a lawyer. She don't even have to do anything. They already came with the lawyer. They sued him. We don't even know where she might not even be in Colorado. She might be in Iowa. We don't know. They don't ever even say. For all we know, the mother didn't even initiate the transfer or the contempt charge. The government just wanted I forget what it was, $11,000, $12,000. And all this, can you imagine how much money this cost, this case and the appeal, and now it has to go back because they didn't do the right thing and they violated his rights. So it cost even more money to the taxpayers, to everybody, and the children because they pay for it too. The judge mentions Turner in the case and cites several legal protections that should be afforded to all defendants in cases such as this. Ultimately, the SCOTUS decided that the person being charged with contempt of court in a child support case does not necessarily have the right to an appointed state-paid attorney. But there are several reasons that must be considered if the parent is denied the attorney upon request. First, there must be a determination of a defendant's ability to pay the civil contempt proceedings. To pay in the civil contempt proceedings. Secondly, because parents who find themselves in contempt of court for allegedly failing to pay support often represent themselves. For that reason, the SCOTUS feared that, quote, providing counsel to the obligor parent would create a asymmetry of representation that will alter significantly the nature of the proceeding, end quote. Well, yeah, you have a lawyer. Of course, that's going to change how the case is going to go. They have a lawyer and you have a lawyer. You're not just sitting there trying to prove your case by yourself. How would appointing a state-paid lawyer to an indigent parent who is forced to represent themselves because they can't afford a private attorney, how would that create a lack of equality of representation? It would for the state. Once the actual attorney is assigned to the case, the parent wouldn't be representing him or herself. So why or how would that alter the proceedings? Negatively, they also wrote that appointing counsel would take too much time. This is why they don't do it. It would take too much time and uh, slow down that time that could be spent on receiving child support payments and make the proceeding, quote, less unfair overall. This is what the Supreme Court wrote. The judges are talking about being less unfair when trying to collect money that someone doesn't have and that is probably owed to the state to recover welfare. Meanwhile, the defendant is having a I'm sorry. Meanwhile, the defendant is having at least two of his or her rights violated. I know a few ways to make the whole process less unfair, and that's to stop arresting parents when they can't afford to pay a debt. That'll solve everything. Just stop doing it. And last, the SCOTUS believed that the substitute safeguards were available to, quote, reduce the risk of erroneous deprivation of liberty, end quote. Keep in mind that Turner was decided in 2011 and the Broyhill trial was held in 2018. So they had plenty of time to study this case and to implement everything that is supposed to be implemented when a contempt of court case comes before them when they're initiated. They had plenty of time, but they ignored it. And there's nobody on any level that goes in and say, are you guys doing this? And that's a problem. Why is that not happening? Why are the politicians and the people that oversee this program, why are they not going in and asking why aren't the agencies going by the protocol that has been set by the Supreme Court based on the Constitution? Suggested safeguards. So if you're going to contempt, if you're being charged with contempt and you're going to court, these are the suggested safeguards that should be offered to you if you're indigent and you don't have the ability to pay whatever the debt is. Here's some of the examples, and this is from a brief from the United States Solicitor General's office. Okay, so they sent a notice to the alleged contemptor that his ability to pay is a critical issue in the contempt proceeding. The use of a form or the equivalent to elicit relevant financial information. There has to be an opportunity at the hearing for the alleged person to respond to statements and questions about his or her, they didn't put his because you know the deadbeat dad thing, about his financial status, e.g. those triggered by responses on the form. And number 4, an express finding by the court that the alleged or the contemptor has the ability to pay. In Turner, it was critical to note that the judges specifically declined to address civil contempt proceedings where child support payments were owed to the state. I have to research that some more. They declined to even look at the state-owed child support debt. That, y'all know that's some bullshit. So in conclusion, the SCOTUS decided that even though Turner wasn't necessarily entitled to a free attorney, because in Turner, I was trying to think, but Turner, she didn't have an attorney either. So I don't think the state was represented. I know he had went to jail. I would have to read that case again, but I think they both were not represented, where in this case, the agency had a lawyer. But don't quote me on that. I'll have to look that up. So he didn't have a right to an attorney, but his due process rights were violated because he didn't receive any safeguards before he was sentenced. So if somebody reached out to me and said that a couple people were facing jail time for contempt. So if you see this video, or I hope you see it, or you see like the title, please watch this. Or if you know somebody that is, facing contempt charges, please share this with them so they know what to ask for, if they are entitled to an attorney, what safeguards they should be offered, all that stuff, because if not, their right to due process is being violated, which is probably the case. When you don't have the ability to pay and they want to lock you up, they're probably violating your due process rights. Okay. But the court specifically declined to address civil contempt proceedings where the child support payments are owed to the state. Okay, I wonder why. That's what I'm typing. So I told y'all this was a lot of information. So I'm gonna keep going. Let me see. It's not too much more, but it's so detailed. I had to break it down, and really I broke it down as short as I could to make sure all the pieces were there, so I wouldn't leave the critical stuff out. Who is that? Hi. I'm glad everybody's here. Thanks for watching, guys. Thanks for the likes. I appreciate it. This is a big deal, especially if you're facing contempt. And I would even go further to say, if you have been convicted after 2011, after this Turner Supreme Court case, and you've been convicted of contempt, and you weren't offered these safeguards or an attorney, I would fight that and maybe even consider a lawsuit. I don't know how successful you'll be, because people aren't usually successful when it comes to suing the government or government officials and things like that. But I would definitely look at it, because your rights were violated. So that's just a side note. I think they need to pay for the violations. That's just how I feel. The judges said that the need for counsel are particularly intense in these cases because the alleged contemptor's present ability to pay is at issue. That ability to pay is the key in every child support case. A person has to willfully fail to pay once that child support order is ordered. But even before that, when they sue you for child support, they're suing you because they're alleging that you refuse to take care of your child. So you're willfully not taking care of your child. So they're accusing you of that. And even in contempt of court, they're accusing you of having money and refusing to provide or to follow this court order. So it's all willful. So if you don't have money to do what this court order is telling you to do, which is pay X amount of dollars a month, then you're not violating the court order. And that's what this is all about. And that's what the whole child support system is. You have to willfully fail to provide based on that court order. So if they answer that question incorrectly, it carries with it a very real risk that the alleged contemptor will be wrongfully imprisoned for an indefinite period with no viable means of performing the act necessary to secure his freedom. The fact that ability to comply marks a dividing line between civil and criminal contempt reinforces the need for accuracy. This is because an incorrect decision can increase the risk of wrongful incarceration. This means that the defendant is deprived of procedural protections demanded by the Constitution in criminal cases. That is a mouthful, but man, that is so critical. During the hearing, the child support agency did not provide any proof that Broyhill had the ability to pay the support, yet refused to pay, and therefore purposely failed to comply with the order. They didn't even try to provide evidence. That's how that's how these agencies and these lawyers, all this whole child support machine, they're so used to going in and railroading anybody that they pull in there because they can. They didn't even bring any evidence that this man had the ability to pay. They just went and showed up to court and wanted to throw him in jail. That's it. And it happened. Um, According to the case document, the burden of proof in civil cases is a preponderance of the evidence. Contempt must be proved beyond the reasonable doubt before punitive sanctions may be imposed. There is no provision specifying the burden of proof for remedial sanctions. Remedial sanctions for contempt under the Colorado Rules of Civil Procedure 107 D2 are civil in nature. Once the agency proved their case, then it was up to Mr. Broyhill to prove that he did not have the ability to pay. But they never proved their case. The judges ruled that because he lacked counsel, he was clearly disadvantaged during the trial. I know parents are going to watch this and say, well, damn, I was disadvantaged during my trial. I didn't get to have a lawyer either. I couldn't afford one. They didn't give me one. I asked for one. They denied me. They threw me in jail. I sat there because I couldn't pay for an indefinite amount of time. Same thing. Everything that I'm reading here happened to so many parents all over the country. And it continues to happen. We have to make it stop. Every year we see and we watch, we hear, we see, we are flooded with people asking for our votes. They are, saying what they're going to do. There's fights. You see your people, your friends, people fall out over what candidate is better, what party is better. It's back and forth, this and that about this stuff, and they do nothing. They don't even discuss issues like violations in family court and child support violations, anything like this. And I don't understand how come we're not demanding answers as to why they are not doing anything. They want your vote. They want to go up to DC or go to the Capitol and get paid. But this is a real problem. There's people sitting sometimes, we don't even know. When you go and look up the numbers to see how many people are in jail and county jail for child support, they don't even have the numbers. They have no data. We don't know how many people are sitting in jail for a child support debt that they can't pay. They're just sitting there. That's prison. I mean, that's slavery. The only way that they can get out is with money that they don't have. That's illegal. That's unconstitutional, and nobody is saying anything. The judge found that even though the government and agencies wanted to resolve the contempt hearing in a timely manner, there was plenty of time to assign Mr. Broyhill an attorney or provide safeguards to determine ability to pay, neither of which they offered to him. Because they don't care. And society doesn't care. As long as it's not happening to that individual or that individual's family, then who gives a damn? But they're coming for you, especially as as things happen. People aren't working. The landlords are knocking at people's door. We want our money, and people start getting sued for evictions and things like that. Then it's going hit people real hard. And then people are going to say, oh, well, damn. Yeah, this stuff is serious. So Broyhill's due process rights were violated because they should have evaluated his claim of indigency and entitlement to court appointed counsel. The appeals court reversed the contempt judgment and sentence. They remanded the case for a new hearing. Broyhill should be granted the right to prove his indigency during the new hearing. If he proves indigency, the judge must provide a court-appointed attorney at the state's expense. Only if Broyhill is proven not to be indigent should the court afford him the opportunity to retain his own counsel, and there should be a new contempt hearing. So he's going to go all through this whole process again, where they could have, if they followed the Constitution in the first place, this would not have taken place. This wouldn't even have happened. But once again, no accountability. And what happens when you give people with authority and power, free range to do whatever they want. They're going to do whatever they want. And nobody says anything. That's what's going to happen. And that's what's been happening. So again, I know this is long and a lot of information for one video, but of course the links are in the description for you. Thank you for the likes. I appreciate it. I hope this information was helpful. This is the only case, like I said at the beginning of the video, that I've seen where Turner versus Rogers from the Supreme Court decision was actually invoked and cited in a case like this. And I might be missing something. I usually, I'm pretty diligent about getting the news and following cases like this, but I don't think I've seen this before. If you've seen it before, you've heard of it, please drop me the link so I can go over the case file. I like to share it with everybody. My email, cshustle1@gmail.com. And we can share more cases like this, at least have a, what do you call it, like a platform, if you will, where people can look up the different case files when they have to go to court, if they have to go to court. At least they'll have some references. Let me see. So if you want to know, if you're not familiar with the Turner versus Rogers case, and you want to know more, what did you say? I was going to say I did a speech, but I said a speech, or I gave a speech, there it is, in DC a couple years ago. And I talked about the Turner versus Rogers case in detail. So if you want to watch that, the link is in the description. And I also put an article up that I wrote. And of course, the references, when I write the articles, there's references, and you can also go there and check that information out if you want to know more. But it's really a landmark case, and every jurisdiction in the country should be following that before they send anybody to jail for contempt of court. Even more importantly, every jurisdiction, they should have been following the Constitution. Before Turner, they should have been following the Constitution and not sent parents to court based on indigency or ability to pay. But okay. For too many years, low-income and poor parents have been hunted, arrested, and imprisoned for allegedly owing a fake child support debt while being prosecuted without any protections from the government. I can't believe that we as a society have allowed this to happen, to go on for so long. But thanks to social media and people networking, we can make it go away. We can make the people in charge of this system, we can make them accountable and make sure that they follow the guidelines that are there. And this is a start. I mean, that's a like I said, that's a big deal, because these judges, I thought I had that judge's name, the trial judge. I might have said it and just didn't even think of. I was reading so much information, but this is a blueprint, and two blueprints now, that if you are being hunted and about to be jailed, this is something that you can use and prepare yourself for when the agency calls you, because it all starts with the agency. And so now you can prepare yourself to, go back and forth with them if you can't get your case closed. That's what I will start right there. Did they serve you correctly? Did they have jurisdiction over you? Because if the jurisdiction, or if they're doing things like this judge did in Colorado, and like they do all across the nation, and don't afford you an attorney when you say you're indigent, they don't do the safeguards to see if you really willfully fail to pay. If they're not even following the basics based on the Constitution, then you have to question everything about the case. You have to question everything. I would want to see everything. And definitely, if they say that you owe a child support, if they say you owe a child support debt or arrears, especially if it's owed to the government, you should audit that immediately. Like right now, You want to find their phone number or their email address and tell them to send you an itemized statement and tell you want it line by line. Make them prove that you owe what they claim that you owe, and then you want to go even further and ask for a contract. Where did I sign that I was going to repay any of these benefits that you're suing me for? Because you probably didn't. You didn't agree to it. You didn't contract to it. So why are you being sued for it and repaid for it? It's because of a common law statute. Which, if you're new here, or if you watched my videos before or read any of my articles, you know I talk about common law a lot and how they use that to recover welfare expenses. So it's intricate how they do it, but now that they've been exposed, I mean, it's easy to break them down. And now that we can communicate through social media and all that kind of stuff, and all the information is going back and forth and being transferred, you know, they have no choice but to restructure everything. And it's a voluntary program, and you have to willfully be proven willfully failing to provide for your children before all this going to jail and all this kind of stuff even enters into the arena. And that's what they're going to have to do. So that's the information from the case. I'm gonna look at my at the comments. I know I wish I want to do that, reach more young men and women and talk to them, because I want to get them before they even get caught up in the child support hustle. And the child support agencies and little local agencies around the country, they actually have curriculum. But what the curriculum starts off in the child support system. They don't talk about, like the birth certificate, the video I did last time. You don't have to sign that right away, and how those people pounce on the new parents during the happy hour and, signing the acknowledgement of paternity. They don't discuss that. It's all starting at the child support center, at the child support program, at the child support office. Well, what about before then? So if you know some young people, you tell them about this too, especially these young men. Know the young women too. We all need to know. And, investigate who you had these kids with. Tell these young people that. Never reference or address the mother. I don't know what that means, Frederick. What does that mean? I bought a purge years ago. I don't know what that means. Is that Timrod? Decision link. Yeah, I put all the links in the description. It's at Timrod. I'm just gonna say Ra. They're in the description. Yeah, it's under the Young and Williams link. Even if you let me hold on. I want to see it. Even if, hey Chief, even if you don't have the money, don't pay them anything. If $5 is what you have to your name and you can't afford to pay don't pay them anything. There's a procedure that they have to. There's a procedure in place. You have to willfully. That means you have the money and you said, the hell with taking care of paying that. I'm not paying it, and you go on your yacht. This was based on back in the what do I want to say, in like the 1300s, and then later on in the Depression. This is based on when women didn't work and men would desert their families and leave mothers and their children destitute. That's not the same thing. Oh, okay. Okay, right. Same thing. Oh, you're welcome, Chief. I think I said that. Michigan is horrible. Michigan is in my top 3 of the most horrible child support agencies that I've ever researched, that I've ever dealt with, that I've ever anything. They are bad. They are pretty horrible. So just make sure you have all the information that you need, Chief. When you go in there and deal with them, arm yourself with the information. They are tricky. And I just wrote an article because I've been talking to this veteran, and they sent me the actual application that they're trying to get him to pay child support, but he's a vet. And disability veteran compensation, the disability compensation is off limits. There's a process for garnishments and all that stuff for child support for veterans disability benefits. So I looked at the form, and the wording on it is misleading, and that's being nice. And that's out of Michigan. I don't know what county, but I wrote an article and said, veterans, look at all this stuff, and that's for everybody. Look at how they word it. If you're not sure what they're talking about, go and look it up before you agree to anything. If you don't agree to it, don't sign it. You don't have to. You do not have to. I'm trying to. I wish I was armed when I was younger. Um, and that's what I want to do for others. Because it's hard to navigate through these systems, and you don't know, and you end up bumping your head and uh, delaying what you can do, or what you know delaying your progress because you didn't have the information. And then I had some people along the way that gave me information, helped me out, and they didn't charge me anything. They just did it out the kindness of their heart, and that always stuck with me. So I'm going to give, if I have some information to give, I'm going to give it, and hopefully it helps, because the people, the power, have been doing this forever. They got their game plan is down pat. We new to this. We don't do this every day, all day. So, especially, when we come up to it, it's a new challenge. It's a new something. So why not? Tell the next person, hey, this is how you navigate this, or you don't have to do that. You can do it like this, because the chips are already stacked up against us. Well, yeah, I mean, I understand that, Grove, but I'm saying the child support agency, before it gets to a judge, is supposed to screen all those cases before it even gets to a judge. So if you have $5 to pay, like, let me say you owe $5,000. Um, I'll love you back. Say you owe $5,000, and they've taken your license, they've taken everything that they can take, and you just don't have it. Well, the agency should take care of that, as far as screening you to make sure what's the issue before it even goes to a judge. That's what Turner, that case, is saying, and that's what this appeals court is saying. These judges are saying they have to screen those cases before they go anywhere based on your ability to pay. A lot of these child support cases are not based on real income. They're based on imputed income, because a lot of these cases are based on or judged on a default basis. So that's a whole different can of worms, because the system is so corrupt. So yeah, I understand what you're saying, Grove, but before, I'm just saying, and letting everybody know, before it even goes there, per the Supreme Court, they're supposed to do a whole bunch of stuff instead of rubber stamping and saying, oh, contempt, contempt, contempt and sending them off, they have to do steps before that. If you can't afford it, you shouldn't even be in front of a judge. Yeah. But I understand what you're saying. It's like changing our way of thinking on how this is supposed to proceed. If that's the case, if you are in contempt, then this is how it should go. It shouldn't go this way. Oh, I can pay $5. I can pay something so they won't send me to court. No, before you even get there, they're supposed to be doing this, and we need to be holding them accountable. So I'm glad that you guys stuck in there with me. That was a lot. I was typing it and I'm like, this is a lot of information. Y'all know I don't like really even being on, I don't even like talking this long. But this is some serious information. It needs to be out and shared, not just with child support professionals, with everybody, because it affects everybody. The child support system is a big government. It's the most successful government program per the government. One of the most successful programs to date. So that program affects everything because it's also a multi-billion-dollar a year program. So it affects everybody, and it's part of the Social Security Act. So, and they're violating people's constitutional rights. So thank you so much for joining me. Thank you for the likes. Thank you guys for subscribing. And let me see. If you want to buy my book, it is available on my website, thechild-support-hustle.com. You can buy it on Facebook as well, and I think Instagram. I'm not sure how that's set up, but definitely on my web page. Now you might go there and you can't get on there, or the pages aren't loading and stuff like that. I don't know what the hell is going on. I go on there and call the people. Sometimes it loads, sometimes it doesn't. So go out, come back in, or send me an email and say, your shit's not loading. So I can go on and look at it and try to fix it. My dad said, they trying to drive you crazy. I said, well, they've been doing it for years, breaking my shit and tearing my shit up and, crashing so I'm used to it. So I'm just letting you guys know, heads up, if it's not working, it's not on my end. I just got to go and whatever I got to do. Share some money. Yeah, knowledge is power. This stuff is, and share it. I'm going to do I'm researching it now because I'm not going to discuss it. I'm going to wait till my next video because I got an issue and I got to research it so we can get some facts straight, because people think just a meme. People share these memes and they're derogatory, racist memes. And that'll be another video. But I just want to say this, I guarantee that every person who is fighting for child support reform is also fighting for shared parenting. I would also guarantee that not everyone who is fighting for shared parenting reform is fighting for child support reform. So make sure when you're fighting a fight like this, family court reform, whatever your fight is, make sure the people to your left and your right are fighting the same fight as you. Because some people just want the bodies. They might not want their mission might not be your mission. They just want your body count. That's what politicians do. And that's what people do, unfortunately, even if the cause is good. Some people just want your body to say, oh, look. So, yeah. I'm glad everybody joined, and I will see you guys next time. Make sure your noties are on. Share. What else? Yeah. Thank you guys. I'll see you next time. And thanks for subscribing. Remember, they cannot ignore millions.